everybody to the latest of our in-house In Focus seminars. You'll be hearing from today, after I've spoken very briefly, my estimable colleagues Peter Wainman and Helen Tringham, who will be talking all about recent themes in data protection 12 months after Brexit, and what are we seeing, what are our clients seeing, what's going on. So I'm absolutely sure you'll find it highly informative and very interesting. Not my subject at all, so I shall be watching with considerable interest myself to see if I can learn something. So just a little bit of housekeeping first, if I may. The webinar is being recorded. So if you're particularly inspired by what you've heard, you can always listen to it again or pass it on to colleagues and so on and so forth, and we'll be circulating that afterwards. And so anyone who hasn't been able to join us today but is watching it on the recording for the first time now, hello. As we go along, if you have questions to ask, and I'm sure you may well do, please use the Q&A box for that. Chat may well be disabled for you anyway, but the Q&A box, and we'll monitor them, and at an appropriate juncture, probably after both Peter and Helen have spoken, we'll deal with questions at the end, or as many as we can get through. Only we as the panelists can see the detail of the questions. So unless you're desperately shy, please don't make it anonymous, because if we don't have time to deal with your question, if you leave your name, that will enable us to follow up afterwards. And may I also just put in a slight plea, if you've got a question, remember to put it in context and refer it to whichever slide we're looking at the time, because occasionally when you come back at the end of the seminar, and sometimes it's difficult to work out precisely what the question was referring to. So give us the help to help you if you could. As I mentioned in the intro, please do link in with any of us. Our details are on the opening slide with the QR codes, and these will be circulated afterwards. We'd like to hear from you. And afterwards, I would please urge you, as many of you as possible, to fill in the feedback form you'll be getting, because we do pay a lot of attention to that, and the topics we cover in these seminars are very, very much informed by what you all tell us you want to hear. So it's certainly not shouting into the void when you fill that in. It's genuinely considered carefully by us all. So I think that's all from me, because everyone's at home. Well, I'm in an office, so if I hear a fire alarm, I'll leg it. I'm sure you've got your own arrangements in place at your houses or wherever you happen to be. So without further ado, I will hand you over to Peter, who can tell you in a bit more detail about what you're going to be hearing about. Thanks very much, everyone.
Good morning, everyone, and thanks, Simon. As Simon says, we're going to be looking at some recent themes in data protection, and we've called it after Brexit, or 12 months, or whatever period of time after Brexit. It's not necessarily about Brexit. This is about what we're seeing, Brexit having happened, what we're seeing from a practitioner's point of view in and around data protection. As ever, that typical lawyery caveat, it's not supposed to be comprehensive. This is about the themes we're seeing emerging, the things we're typically advising on, and so the things we think are probably relevant to you. And obviously, if there are other things that occur to you that we haven't covered, as Simon said, do put them in the chat. Happy to look at covering those today, or in another session if there's not time today. So I'm going to do the first half of the session, or thereabouts, covering this from a commercial lawyer's point of view, so from a drafting and advisory point of view. So I'm going to be covering international transfers, some of the developments around that recently, so the UK's adequacy decision, the new standard contractual clauses that the EU has issued, the current position in the UK, and the new international data transfer agreement that the ICO's issued, plus also the new code of practice that's come into force, and the initial stages of the data reform consultation that the government's currently doing. And then I'm going to hand over to Helen, who's going to be coming at this from a disputes persons angle, but also a still data protection practitioner angle. So looking at subject access requests, data breach reporting, data breach claims. We usually work things between Helen and I. We both do the advisory stuff. If things come in relating to contracts, that's my bit of the firm. If it's data breaches, I phone Helen for help. Okay. So I thought for the international transfers bit, given that it's been quite busy over the last few years, and this may be telling you things that you already know, but I thought it was worth doing a quick recap on things that have happened, because it's as I say, it's been busy in the world of DP transfers. So if you remember, back in 2018, we had the new GDPR, and our UK's DPA came into force. And so that continued the restrictions on transfers of personal data to third countries, in other words, outside the European Economic Area that we were used to under the old Data Protection Act, but introduced some new changes, So where historically those restrictions applied only to controllers, now they apply to both controllers and processors. But also that the new legislation revisited the lawful basis for making those transfers outside the EEA and arguably limited those, narrowed them. So, for example, what was previously a transfer permitted where it was necessary for a contract became a more difficult basis to rely on than it used to be. And that puts an increased dependency on the use of standard contractual clauses for those international transfers. And I'm sure those that were working in-house at the time went through the same process as we did of putting in place all sorts of data transfer agreements, data processing agreements in and around that time, including using the standard contractual clauses. Then January 2020, we had Brexit, and then a transition period through to December 2020, where data flows between the UK and EU continued to be permitted, and then a trade agreement bridged through to June this year. And through that transition period and under that bridge, the transfers between the UK and the EU were still permitted, so we weren't needing those SCCs for UK EU transfers. In July 2020, we had the Schrems II judgment, which, if you remember, brought to an end Privacy Shield in terms of transfers to the US, meaning that suddenly we had to be looking for other lawful bases for those exports of data to the US. And that Schrems II judgment also brought in some new requirements around the use of SCCs to establish that broadly where you were using them, that they were appropriate in the circumstances, given the nature of the transfer and the country you were transferring the data to. And it's probably fair to say still leaving some questions open in terms of the validity of those SCCs, but without, frankly, a better option available, particularly given those, as I said, the narrowing of the bases for transfer. Things carried on moving. Just at the 11th hour, when the trade agreement bridge was coming to an end in June, the UK got its adequacy decision. So, in other words, transfers from the EU to the UK were permitted because the UK was deemed to have provide an adequate level of transfer. And we also then had the EU adopting some new standard contractual clauses and new Article 28 processing clauses. I'm going to talk about both adequacy and SCCs in a bit more detail in a moment. And then in August, the ICO then opened its own consultation on its own new international data transfer agreement, distinct from the EU's SCCs. So I'm going to talk into a bit more detail about those last few developments. So, on the first of those, the decision, the adequacy decision. So, there have been a number of draft versions of this adequacy decision kicking around earlier in the year, but in June, the EU formally adopted the adequacy decision that looked similar in material respects to the one we'd seen before. It's fair to say that although I think most people assumed that there would be something, an arrangement would come in place to allow data transfers to continue, it wasn't. It wasn't straightforward, the discussions leading to the adequacy decision being adopted, and there was a lot of talk and information coming about the challenges that the EU was facing in terms of getting comfortable with some of the laws in the UK around the data, and but nonetheless, from a straightforward data continuing to transfer point of view, we got the adequacy decision. So under that adequacy decision, personal data is allowed to continue to flow to the UK from the EU under the GDPR and law enforcement directive from those EU countries. So that came into force on the 28th of June. So the good news there is that means that data can flow between the UK and EU, vice versa, without the need for standard contractual clauses or any other document. That's effectively a lawful basis for those data flows. And the initial adequacy decision is for 4 years unless it's renewed, and the Commission has kind of given itself the ability to continue monitoring the situation here for any deviation from the current level of support. So in theory, that adequacy decision could still be revisited, suspended, repealed, amended, and so I suppose that was a predictable outcome. It was never going to be the case that the adequacy decision was going to be set in stone forever, regardless of what the UK chose to do with its own legislation. So I don't think we should be unduly alarmed by that. And it's worth mentioning that transfers for immigration control are currently excluded from that decision. On the point around monitoring the position in the UK, I'll come back to that a bit later when I'm talking about the potential for reform of data laws in the UK later in this talk. So that was good news in that meant we had certainty about data transfers from the EU to the UK, and it was also good news in that we didn't have to put in place a load of new administration and bureaucracy for those data transfers. I think it's fair to say from our work with a number of clients, some people had to put in place interim arrangements in case the adequacy decision didn't come through. But where we are now is that's dealt with by those decisions rather than needing those separate contracts. So there's just a few links to the kind of key information, and I believe I'm right in saying we're going to be circulating the slides afterwards, and so if you wanted to follow up and read any of the decisions, they're on the slides. Alongside the adequacy decision, we've also seen development around the use of these SCCs, the standard contractual clauses. So broadly, we've been very used to some rather venerable standard contractual clauses, or model clauses as they're sometimes called, for data transfers for many years. Well, probably half the time I've been practicing as a data protection lawyer. So the old standard contractual clauses predated the GDPR, meant that you needed to have both GDPR compliant clauses and standard contractual clauses to ensure you were compliant, and also only covered limited circumstances, so controller to controller and controller to processor. So that led to a number of wrinkles over the years, and quite a lot of discussions we've had with clients over the years about circumstances that either fell outside of those scenarios, or as I say, where you were trying to align the SCCs, the old SCCs, with what's in the GDPR. So there was a period of consultation, and in June 21, the new SCCs were approved. So this is to apply to controllers and processors in the EU, transferring personal data to third countries, i.e. outside the EA, where there's no adequacy decision. As I say, so that means we don't need them for a transfer to the UK because there is an adequacy decision. And as I say, that also they apply to processors as well as controllers. So that's new. Historically, the SCCs were only for controllers exporting data. So they are rather different in terms of approach than the old contracts. So there's a modular approach. So we've got different modules for the different scenarios that the SCCs cover. So we've still got controller to controller, we've still got controller to processor, but we also now have processor to processor, processor to subprocessor, and processor to controller. And the last two modules are particularly welcome on the basis that historically that we had no SCCs to cover that scenario, and in the absence of an obvious lawful basis, there was always a problem or a gap there where you had those EU processors transferring to controllers outside. The other good news, as well as covering off those scenarios, they also cover the Article 28 requirements of the GDPR. And when I say that, so the GDPR has a set of requirements for controllers and processors to put in place contractual arrangements between them, regardless of whether there's an export from the EU. And the old SCCs, as I said earlier, didn't cover off the requirements of Article 28, whereas the new ones do both things. So if you're using these SCCs, you don't need a separate DPA. The SCCs will cover off the Article 28 obligations, as well as the data transfer obligations. So they've allowed for a period of 18 months to transition to the new set of clauses. So there's no immediate requirement to replace SCCs that are already being used. But they're available for use immediately for new arrangements put in place now. So this is, as I said, this is for transfers from the EU to countries outside the EEA. So this would apply to, for example, if you have offices in France or Germany and you're transferring from the French or German location to the United States, for example, then this would be a situation where you would look at using the new SCCs. You still do need to consider these supplementary measures that Schrems II introduced. In other words, the SCCs on their own will not necessarily be enough to ensure an adequate level of protection when the data is being exported. So you do need to still consider things like the technical protections for the data when the data is being exported, and the guidance around the new SCCs gives some indication of the sort of things you should be doing there. So again, that's broadly good news that around the introduction of the new SCCs for people with operations in the EU. Position in the UK, obviously we are now outside of the EU, and there was the question of, well, what's the UK government or the Information Commissioner's Office going to do with international data transfer now? We don't have to follow the European model, and I'll mention this point a few times. The tension always being that we're very glad to have our adequacy decision, and that makes life a lot easier, and we don't really want to put that at risk. And that adequacy decision is partly based on our data protection laws. So if we were to introduce bases for transfer that didn't comfortably meet the EU standard, then that could in theory be the sort of thing that the Commission would look carefully at. So there was a question of would we simply adopt the new European SCCs, or would we do something slightly different? So we haven't adopted the new SCCs. Where we are right at the moment is if you're transferring data from the UK to third countries, not to the EU, that's okay. That's adequate. We would still need to use the old EU SCCs. Now, the ICO has helpfully published a UK version of the old SCCs, updated to reflect the UK GDPR with things like the references to the appropriate legislation and the transfers from the UK and so on. But we do have the same limitations that we used to have with those old SCCs in the EU. In other words, we've only got controller-controller and controller-processor transfers, so we don't have them for processor-controller or processor-sub-processor transfers. And at the moment, we also, they don't reflect the full requirements of the GDPR, so you would also, the Article 28 requirements I mentioned earlier, so you would also need a separate DPA to cover off those requirements too. So the good news is that the ICO's addressing this. So in August, the ICO launched a consultation on its own approach to effectively tackle the problem that the SCCs tackle. So that's a new, and we love acronyms in the world of data protection. It's not SCCs this time, it's an IDTA. Obviously calling them UK SCCs would have been too convenient. So we've now got a draft international data transfer agreement in circulation that the ICO has prepared. So that would effectively, as I say, replace those old SCCs in terms of compliance for international transfer, does take into account TRIMS too. So under the DPA, that the ICO is required to consult on those before they're implemented. That consultation is about to close tomorrow. So if you're worried about or have a strong view on what they might say, and want to have your say, now's the time to go and have a read and make your submission. So a few things to say about what's been published from the ICO on this. So we've got a consultation paper that does raise some questions around interpretation. So for example, do you need a transfer from between legal entities to count as a restricted transfer, so in other words, how is a transfer within the same organization where it's the same entity but with different locations, how is that affected by the IDTA rules? It also asks for views on the proposed transfer risk assessment tool that's being introduced, which sort of goes alongside those TREMS 2 requirements to be assessing the risks around the transfer and the model IDTA itself. That it's looking at how should this work alongside the SCCs, and whether that there should be different IDTAs to validate the use of the transfer agreements from other jurisdictions. In other words, if we're happy with our UK IDTA, how should that work alongside the EU's SCCs? Do you need both, for example, if you've got transfers from both locations, or will it be valid to rely on the SCCs to also meet the UK's requirements? So the ICO has also published this risk assessment tool, as I mentioned, looking at, for example, whether it's a useful tool. Is this a good thing, and is this helpful? Does this help bodies comply with their obligations, or is this too much information? So again, opportunity to feedback on that. And then we've got the draft of the data transfer agreement with extensive guidance. So at the moment, it's envisaged that the IDT will be signed as a separate agreement. So a standalone agreement where there would still be a separate services contract, data sharing or process agreement between the parties. So this is primarily focused on the international data transfer element. I think that's an area that I can imagine the consultation might get some feedback on, because I think most people will be looking to try and make this as streamlined as they can. So we'll see where that lands. The other interesting thing they've published is an addendum to the EU's SCCs. So again, these are all just drafts at the moment, subject to the consultation, but the argument is if a UK organisation, for example, with operations across the UK and the EU, were to use the SCCs, what would they need to do to the SCCs to bring them in line with the UK legislation? And so the ICO has published an addendum to try and result in a document that would cover off both the EU requirements and the UK requirements, which I think is a helpful concept. Certainly a number of the questions we've been getting from clients is about, do we have to do both, as in do we have to have an SCC and an IDTA? So I think that's it's welcome that the ICO is looking at that, and so we'll again see where that lands. So there's I'm afraid a plethora of different links, although as ever with the ICO's website, it's fairly easy to track this stuff down if you're hunting anyway. So I mean, this is massively oversimplifying, but a quick chart. If you're transferring data from the EU to the personal data from the EU to the UK, or the UK to the EU, then you can rely on the adequacy decisions, so no SCCs required. If you're transferring personal data from the EU to third countries, not including the UK and others with adequacy, then you need to use the new SCCs. And if you're transferring from the UK to third countries at the moment, for now, you need to use the old SCCs where possible. As I say, they don't cover all scenarios until the new IDTA comes into force, which we'll see they need time to read the feedback from the consultation and then issue those. So a quick one on data sharing, that's it on international transfers. The ICO has also published an updated code of practice for data sharing, came into force yesterday, I believe. So it's intended to be a practical guide replacing a 2011 code. It's a statutory code. In other words, the DPA provides for the ICO issuing these codes. And so the ICO has said that they would take it into account when looking at enforcement and so on. That's not to say that it's a legal requirement for people to comply with it, but clearly if it's been issued by the ICO as a statutory code and the ICO is going to be enforcing, then it's going to be very relevant to assessing the ICO's view of the data sharing you're doing. So it looks at what sort of things should you put in data sharing agreements, looks at accountability, fairness, transparency, lawfulness, security, rights of individuals. There's quite a lot of information in there. It does cover off a few specific scenarios too. An observation for us is that it's very helpful as a pretty comprehensive look at the issues that arise, particularly where you're looking at controller, joint controller scenarios. It does tend to err on the side of completeness. So sometimes we find for fairly simple data sharing arrangements, there's quite a lot in there to think about for something that may be relatively low risk, but nonetheless, it's a useful reference point. Again, a couple of links for you there. And the last point I was going to raise was another consultation. As I said, sorts of change and things happening in data protection at the moment. So the government's launched its consultation. This one, you've got a bit more time, closes 19th of November. And as they said, this is the first step in the process of reforming the UK's regime for the protection of personal data. So they say this is a proposal to build on the key elements of the current GDPR, such as data processing principles, data rights, mechanisms for supervision and enforcement, but the proposals are aimed to deliver an even better data protection regime. And I think they've deliberately used the word better rather than more robust, because I think one of the tensions that the changes is looking at trying to achieve is maintaining, well, just quoting from their comments, maintaining high data protection standards. In other words, at a level that meets our adequacy decision approval, but without creating unnecessary barriers to responsible data use. And it's fair to say the government's very keen to exploit opportunities around data, particularly around research and so on, and where there's a perception that the current regime makes life harder for people, I think government's looking at where there are opportunities to change our regime to make that more straightforward. I think, as I said, this one will be very interesting, both in terms of what comes through in the lobbying and also the European Commission's response to where we get to with it. Again, an awful lot more information in the consultation document. So that's it from me, and I'm going to pass over to Helen to pick up on subject access requests.
Thank you very much, Peter. For those of you who've not been fortunate enough to deal with a subject access request, we find that they're often made by disgruntled employees, litigants trying to seek early disclosure, or individuals looking for a smoking gun for some ulterior motive. We're seeing our clients receive an increase in subject access requests, and lots of clients ask if they can simply refuse to respond to one. Well, unfortunately not. SARS are motive blind. It doesn't matter if there's ongoing litigation and the data subject is using it as a fishing expedition. You have to respond to it. However, requests may be refused if they are manifestly unfounded or excessive. Alternatively, a reasonable fee may be charged for responding to such requests. Well, what counts as manifestly unfounded? The ICO says that a request may be manifestly unfounded if the individual has no clear intention to access the information or is malicious in intent and is using the request to harass an organisation. In relation to whether a request is manifestly excessive, the ICO guidance says it needs to be clearly or obviously unreasonable. This means taking into account whether the request largely repeats previous requests and a reasonable interval hasn't elapsed between the two. We had a client who had a rogue employee who hacked into the client's system and downloaded the entire HR database, including complaints and grievances. He then used that information to try and intimidate the client and its employees. He put a subject access request in, and the client didn't want to respond on the basis that it was manifestly unfounded or excessive. In short, the ICO told the client to get on with it. So our experience is that it really is quite hard to rely on manifestly unfounded or excessive as a reason to refuse to comply with the SAR, but we'll see later what the government says in relation to that. Moving on and pointing out the obvious, in our experience, dealing with SARs requires an awful lot of resource. We had a client who had a SAR, they put the employee's name into the system and it came up with over 1 million hits. That would take a team of 10 people around 47 weeks to complete. And that's on the basis that each document just takes 1 minute to review and redact, which is clearly not the case. We were able to help that client narrow the search, but the point is it really does take a lot of time and resource. So you need to get on with your SAR as soon as possible. I wanted to mention the scenario where you have a SAR and potentially an employment or civil claim running at the same time. You're hoping to settle the claim, however, you need to be mindful of the SAR as well. The starting point is that data protection rights are freestanding rights. You can't contract out of them. That means there's nothing you can do to stop a data subject making a SAR, and there's nothing you can do to prevent the data subject from complaining to the ICO. Therefore, the reality is that you could enter into a settlement agreement and the very next day the data subject put in a further SAR. If settlement of a claim is reached, you should ensure that any loose ends around any outstanding SAR are tied up. I'm sure you know there's a real shift in environment around settlement agreements following the Me Too campaign. You therefore need to find the balance between compromising the data protection rights in relation to the SAR against not preventing the data subject from reporting the matter to the ICO. If the matter is settled, we recommend that as part of any settlement, you ensure that the data subject confirms that they no longer require their SAR to be actioned. Then if they later complain to the ICO, there's a clear reason and paper trail as to why you didn't respond. The final point in your settlement agreement, make sure there's no reference to preventing the data subject from complaining to the ICO as the regulator. Indeed, the feeling is that regulators want to see express provisions in settlement agreements, making clear the right to complain to the regulator still exists. So moving on, Peter has mentioned already the government consultation. In relation to SARS, the government's made two key observations. First is that SARS are time and resource consuming. And second of all, that SARS sometimes are used outside of their statutory purpose. That's the government acknowledging that SARS are frequently used by people with an ulterior motive. I said earlier that you can refuse to respond to a SAR if the request is manifestly unfounded or excessive. The government's noted that some organisations find that threshold difficult to navigate. The government's proposal to address those two issues is to introduce a fee regime similar to that under the Freedom of Information Act. Under the Freedom of Information Act, you don't have to comply with a request for information if you estimate that the cost of complying with the request would exceed the appropriate limit, which is 24 hours or 18 hours, depending on the type of body that you are. Under the proposal, organisations would still have to deal with requests to the extent possible within that time limit. In addition, under the Freedom of Information Act, the public body may refuse a vexatious request. That would be assessed taking into account the context and history of a request, including the identity of the requester and any previous contact with them. The government suggests that adopting a similar threshold instead of the manifestly unfounded or excessive threshold would help prevent organisations responding to requests where access to personal data or concerns about its processing are not the real purpose of the request. So in summary, the government's proposal is that you wouldn't have to spend longer than the appropriate limit of time on a SAR, and you could refuse a vexatious request. Moving on to the next slide, on breach reporting. The current breach reporting threshold is relatively low, asking that organisations inform the ICO of any data breach unless the personal data breach is unlikely to result in a risk to the rights and freedoms of natural persons. In practice, that's led to many organisations over-reporting in order to avoid any regulatory action being taken against them. In order to reduce that over-reporting, which is burdening the ICO, the government's proposal is to amend the current threshold so that organisations must report a breach to the ICO unless the risk to individuals is not material. What would constitute a non-material matter would need to be explained further by the ICO. The final thing I wanted to talk about is claims threatened by individuals. In one of our earlier in-house updates, my colleague Richard Seitz gave an overview of data breach claims, that can be accessed on our in-house InFocus hub. The approach claimants take to such claims is known technically as the kitchen sink approach, where all possible heads of claims are thrown in. So we usually see this sort of claim framed as a breach of privacy, misuse of private information, breach of the data protection law, breach of confidence, and negligence. Richard gave some top tips for responding to those claims, but we've got a bit of an update for you with regard to the case on the slide. In these types of claims, one of the benefits of the kitchen sink approach for claimants is they can try and rely on after the event insurance. ATE insurance covers the risk of a claimant being ordered to pay the defendant's costs, which means that the individual claimant doesn't have any real exposure to an adverse costs order. Most ATE insurance premiums are no longer recoverable from the other side as part of the cost of litigation. However, ATE premiums are recoverable in publication and privacy proceedings. That's claims in defamation, breach of confidence, and misuse of private information. This is one of the reasons why claimants try and include these heads of claim as part of a data protection claim, namely to try and remove their exposure to an adverse costs order by obtaining ATE insurance. This can often mean that they have no skin in the game when it comes to settling a case because they have no risk of an adverse costs order being made against them. However, help for defendants to these claims has come in the form of Warren and DSG Retail Limited. This was a claim that followed a malicious hack on the point of sale system of Currys PC World and Dixon's Travel, which were operated by DSG. The claim alleged that his contact details and date of birth had been lost in the malicious hack, and as a result, he had suffered distress. He brought the kitchen sink claim. The claimant's claims were all based on a cyber attack, therefore the alleged wrong was a failure to have sufficient security, which allowed the attacker to access personal data. The court struck out the breach of confidence and the misuse of private information claims, crucial for the recovery of after the event insurance. because those claims require a positive action from the defendant. There hadn't been any positive action here. Instead, a third party had infiltrated the defendant's systems and had taken the information. The judge also dismissed the claims for common law negligence because there was no need to impose a cautious duty of care where a bespoke statutory regime already existed, namely the GDPR and the Data Protection Act. This is a significant development as it should discourage some individuals to adopt the kitchen sink approach. What does this mean for you from a practical perspective? Well, should you suffer a malicious hack where your records are compromised, and should you receive claims from people affected, you should rely on this case to minimise the heads of claims that are advanced. In turn, this should mean that the claimant is not entitled to ATE insurance, which hopefully makes the claims easier to resolve at an earlier stage, saving time and money. Simon, back over to you.
Fantastic. Thanks, Helen, and thanks, Peter. Got a few questions to answer. There was one earlier, slightly more general question about what do we mean by the adequacy decision. I think based on where that came up, that was then answered by how you went on with it. So I suggest maybe that's one we'll follow up with afterwards if the questioner is still concerned about that. But a couple of more specific ones. Between you, decide how you answer. I think the first one's probably for you, Peter, since it came up during your talk. Given the thousands of contracts out there, what is the level of risk around the use or non-use of SCCs? Has a regulator ever taken action in this area? What can you tell us about that?
So, I think the implication of the question, I think, is right. In other words, there are thousands out there. The regulators, the ICO, only has limited resources to check up on every use or non-use of the appropriate IDTA SCCs. Is going to be beyond their means. So that's absolutely true. It's fair to say that simply not doing those things is unlikely to immediately result in enforcement action. That the ICO hasn't got time to audit everyone's appropriate use of those contracts. So, and it's fair to say on the question of, how much enforcement action do we see around this? Not very much is the answer. So the flip side is, I think the ICO wouldn't be very sympathetic to an organisation that knew what their responsibilities were given perfectly simple tools to implement to address those responsibilities, and had made no effort to do something about it. So I think if organisations have made efforts, but for example, on the scenarios, the loopholes I mentioned, where we were talking about the situation where we don't currently have old SCCs or an IDTA to cover off processor to controller transfers from the UK, I think the likelihood of the ICO taking enforcement action for a scenario that nobody currently has a brilliant solution to, and that's been a problem for a very long time, is very low. I think it wouldn't do the ICO's reputation any good if they were penalising organisations for something that's sort of frankly more the legislator's fault than theirs. But on the other hand, where there's a perfectly straightforward SEC solution to a problem and people haven't bothered, if the ICO found out, for example, most obviously, if there was subsequently a data breach and it was found that let's say somebody was using a hosting provider in the States, there was a data breach, there were no SCCs, that would undoubtedly be an exacerbating factor in any kind of enforcement action. So that's a very long answer to say, the question, implies the right point, which is not sorting it out straight away is unlikely to result in immediate action. On the other hand, I don't think that's an excuse not to try to do the right thing.
Fantastic. Thank you, Peter. The next one I think is for you, Helen, probably. Doesn't putting Freedom of Information Act style conditions in place effectively erode the rights of individuals? Why should we make it easier for companies at the expense of an individual wanting their information? So a question striking a blow for the rights of the individual there. So Helen, what's your view on that?
Yeah, absolutely. I suspect that there is a risk that could happen, but ultimately I don't think that's what the government's seeking to achieve. If an individual has a genuine desire to access a copy of their personal data, I'm not sure the freedom of information style conditions would prevent them from doing that. And also, if an individual did want to see a copy of their personal data and it'd been limited because of those conditions, there would be nothing stopping that individual putting in a further subject access request to truly understand how their personal data is being processed. I think it's very unlikely that an individual wanting to see their personal data would be treated as vexatious under the proposal. So I don't think it would compromise the individual's rights. I think what it's trying to do is acknowledge that subject access requests can be hugely burdensome for organisations, and trying to strike the balance between an individual's rights without crippling organisations.
Fantastic, thank you. A couple more, we've got a few, but a couple more we can fit in, and then maybe one to follow up. The next one for you, Peter, we better do this one now because it's an anonymous attendee, so we can't follow up with this one. So the question is, sorry if I missed this, but as it stands, would the IDTA get around the UK Data Protection Act's equivalent of Article 28, or would you need both a DPA and IDTA?
Is a very good question, and I think the answer is, as I said earlier, that the current draft consultation document assumes there may be a separate data sharing, data processing agreement. So you may need both, but I think that's one of the key areas of the consultation of are we going to end up needing both or not? And I think obviously the approach taken with the EU SECs is not. I don't think that's absolutely clear yet from the UK's approach. I think we'll see how that pans out. I think my own view would be it would be surprising if where the ICO gets to with it is something that involved more bureaucracy than the EU. On the basis, on the whole, the ICO has tried to reduce the bureaucracy, but as I say, that they have acknowledged at the moment that there could be a separate data sharing arrangement. So let's see where that one lands. Sorry, that's a slightly hedged answer.
Fantastic. There's one other question for you, Peter, but I think that's one you can specifically follow up after, because I'm conscious of time. So one last question, probably for Helen, I guess. Are you seeing an increase in Sars support and advice requests from NHS organisations? And are there any trends that these are showing that you can share with us? So a sector-based one, I don't know if you're able to answer that, Helen.
Yes, in short, yes, we are seeing an increase in Sars. I know that because we've got a team of paralegals that helps our clients with their subject access requests, and that team is incredibly busy. In terms of trends, the only thing that I would observe is that normally it's a SAR in conjunction with an employment tribunal claim, and often with civil litigation as well. And as I said earlier, they often come to an end together when the underlying complaint is resolved. But as I said, they take up a huge amount of resource, and I think individuals are becoming more savvy and aware of their data protection rights.
Yeah, no, that's interesting. My wife is an in-house lawyer, and she was talking to me about her companies dealing with SARS and the amount of burden, and whether their team needs to recruit more people, because there's undoubtedly more and more of this sort of stuff going on. Well, and I've just seen we may have had another last question in. I think these are ones, because we've gone on. We will follow up.
Up to you, but I could probably answer, because they both asked the same question pretty much the same way, and I could do it in 10 seconds probably. So,
right, 10 seconds starting now.
Post Privacy Shield, what do we do for transfers of data from the UK to the US? The answer is you would need to use the SCCs or IDTA when it comes into force, regardless of whether the jurisdiction is USA or UK, on the basis there is a data transfer there. There you go.
There you go. Marvellous. Less than 10 seconds, I think. Fabulous. Well, look, we'll apologies if we've not got to every other question. We will follow up. As I said before, if you, when you receive it, could fill in the feedback form and give us your thoughts and ideas for future topics, because we do very much listen to that, and we very much want to hear what you want to hear from us about. In the meantime, it just means to say thank you very much to both Peter and Helen for their time today and their talks, which were tremendous. And thank you for so many of you for attending and watching this webinar, and hope to see you at the next one. Thanks very much, everyone. Bye.